Section 20, power of controller to make orders regarding substitution of applicants, etc. When an application is filed, the applicant on whose behalf the application is made is mentioned in the application itself. Now, assume that after a period of time, the applicant wants to assign the invention to another person even before grant. It is still in the application stage, he wants to assign it, or it is a part of a company, he wants to sell the company, or he wants to sell the invention alone, like it is a research organization, somebody has shown interest in the invention. So, they have an agreement to sell the invention to that person. In all these cases, there could be a transfer of title, a transfer of ownership from the applicant to another person, either through a sale of a company, either through an assignment, or through the sale of the invention or the technology itself. In all these cases, there has to be a substitution of the name of the applicant. Now, after the grant, if there is an assignment, there are provisions under the Act where a patentee can be substituted. We are not talking about a patentee substitution. We are talking about an applicant whose name is there in the application. How do we substitute a new applicant's name? Because for certain reasons the applicant has changed. The person who was the applicant is no longer the applicant and somebody else has come in his or her place. The controller has certain powers. Now, let us look at that. 21. If the controller is satisfied on a claim made in the prescribed manner at any time before a patent has been granted. So, 20, a point to be noted, section 20, the powers of the controller under section 20 is before the grant of the patent. So, how do you change the name of a patentee? Section 20 does not apply, because the patentee, we call him a patentee when the patent is granted, we do not call him an applicant. We refer to the person as an applicant up until the time of the grant. After the grant, he is called a patentee or the patent holder. So, to substitute the name of a patentee, this is not the provision. So, you need to bear that in mind, because this provision applies before the patent has been granted, that by virtue of an assignment or agreement in writing. Now, these are the things that you need to note. Before the patent has been granted, by virtue of any assignment or agreement in writing made by the applicant or one of the applicants of the patent, or by operation of law. Okay, there are three things. There could be an assignment. Assignment is where you give your right to another person. There could be an agreement. The agreement can be a takeover agreement if it is a company. It can be a share purchase agreement if it is a company. I purchase the majority shares and I become the holder, or 100% shares. It could be any agreement which is critical for this transaction, or by operation of law. By operation of law, say the company is acquired by another company, operation of law, or the company becomes bankrupt, the company does not have money and all the assets of the company are sold, the patents alone are purchased by another party. So, that is operation of law. The patents are purchased by, when the company gets into bankruptcy proceedings, patents being the asset of the company are purchased separately. So, that is something we call operation of law. The claimant would, if the patent were to be granted, be entitled thereto, or to the interest of the applicant therein, or an undivided share. Now, the claimant is the person who wants to come in as the new applicant. Okay. So, claimant would be, if the patent is granted, this is in the future, if the patent is granted, would be entitled thereto. He will be entitled to becoming the applicant, or to the interest of the applicant, or an undivided share of the patent or of that interest. The controller may, subject to the provisions of the section, direct the application to proceed in the, so the controller will direct the application to proceed in the name of the claimant or the names of the claimant and the applicant or the other joint applicants accordingly as the case may require. there are three instances where, so we understand in this section we try to understand who the claimant is. There is a claimant here. Claimant is not the present applicant. Claimant we understand as a person who has received something from the applicant which entitles him to become an applicant. So, the claimant is used as the future applicant or the new applicant, let us call him the new applicant. Now, this provision also contains instances where only an interest is given, the entire invention is not sold, the entire invention is not given. So, there are three applicants, they all together want to bring in the fourth applicant. Do you understand? There are already three people, because they can be multiple, you can make joint applications. There are already three applicants, say there are three scientists had filed a patent in their own name. A fourth person has also helped them, but his name did not come in the application. Now, they make an agreement with the fourth person to say that we recognize your right, you had made a contribution, and they say that we will include you as a inventor. Now, based on that agreement, it is an agreement in writing, the fourth person who can be regarded as a claimant will not get the entire invention, he will only get an undivided share, that is 1/4 of the invention, if that is the arrangement. So, this provision applies for instances where a person gets the full patent, full interest in it, and also cases in which he may be a joint applicant. So, that is why it says a claimant who by three things, by agreement, by assignment, or by operation of law. Operation of law, I said there is a bankruptcy proceeding, something a legal proceeding based on which the claimant came to acquire an interest. So, there is a claimant or claimants, it could be one or more people, and the claimant by virtue of three things, an agreement, assignment, or operation of law, was entitled to the application itself. He was entitled to the application itself, or to an interest, or to an undivided share. So, three things, he was entitled to the patent, the application, the patent is in the application set, or to an interest, or to an undivided share of the patent or that interest. In such cases, the controller shall direct the application to proceed in the name of the claimants, claimant or claimant, or in case there are existing applicants who also continue with him, then in their names jointly. So, I hope you understand the scheme. There is a claimant, the claimant gets an interest in the application based on three things, there is an agreement between the existing applicants, or there is an assignment, or by operation of law he gets an interest. And what kind of interest is that? He is entitled to the application or to an interest in it, which is not the full right, but a part of it, or he is entitled to an undivided share or an interest in that undivided share. Now, so when he is entitled to the invention itself or to a share in the invention, then the controller shall proceed as if the claimant has become an applicant. The controller shall proceed with the claimant now shown as the applicant. So, the word claimant is used here so that we do not get confused with the old applicant and the new applicant. 22. No such direction as aforesaid shall be given by virtue of an assignment or agreement, any assignment or agreement made by two or more joint applicants for a patent, except with the consent of other joint applicants. Now, what did we see in 21? In 21 we saw a claimant making a claim that he should be treated as an applicant. We saw that in 21. 22 states, if there are joint applicants, then the consent of all the applicants is required before including somebody as a claimant. If the controller needs to give a direction, this provision requires the claimant to make an application to the controller under form 6, and the controller will have to give a direction. So, the direction is what is being sought under this provision. 22 says that the controller will not give the direction till the consent of all the joint applicants are received. Let me give you an example. There are 3 applicants to a particular application. Now, A, B and C. A and B have an agreement with D and they want to bring D into the list of applicants. So, D becomes the claimant. D's agreement is only with A and B, but not with C. But C is an existing applicant. There are 3 applicants A, B and C. A and B have an agreement with D. Based on that agreement, they want to bring D as a claimant. They want to bring him as a new applicant. As per 22, the controller will not do it. He will not issue a direction till they get the consent of C. So, the provision is very simple. In case you need to bring, if you are a joint applicant with others, you cannot bring a new applicant without everyone consenting. So, that is what it says, except with the consent of other joint applicants. So, all the joint applicants A, B and C will have to consent. If all of them do not consent, the controller will not pass a direction. It is just to protect the interest of the existing applicants. 23. No such direction as aforesaid shall be given by virtue of any assignment or agreement for the assignment of a benefit of an invention. So, this is with regard to assignment of a benefit of an invention, unless A, the invention is identified therein by reference to a number, identified by reference to the number of the application. B, there is produced to the controller an acknowledgement by the person by whom the assignment or agreement was made, acknowledgement by the person who made the assignment or agreement that the assignment or agreement relates to an invention in respect of which the application is made, that it relates to the invention. Or C, the right of a claimant in respect of the invention have been finally established by a decision of a court. This is where by operation of law, you saw that operation of law, the rights of a claimant has been established by a decision of the court. Or D, the controller gives direction for enabling the application to proceed for regulating the manner in which it should be proceeded under subsection 5. Controller gives direction subsection 5 under subsection 5. We will see what subsection 5 is, but in this, in 23 we say that it puts the requirements for the controller to pass a direction. Before passing a direction saying that somebody is a claimant, there are certain requirements. The first requirement, no such direction as aforesaid shall be given by virtue of an assignment or an agreement for the assignment of a benefit. So, where there is an assignment of a benefit in an invention, as assignment is where you want to give a part of the right to another person, then the controller will insist that the invention is referenced by the application number, because we are still in the application stage. So, the assignment, the agreement should refer to the application number. So, if the parties come with an agreement without the application number mentioned in the agreement, the controller will not act by it. So, there can be a question, what are the requirements of the document that has to be filed along with form 6? You can give multiple choices. It should contain the patent number, it should contain the application number, it should have a cross reference to all the names of the party. You can come up with many answers. The correct answer will be, it should have a cross reference to the application number. Okay. So, you could create questions on that, but understand this is yet another case of cross reference. So, you could make a chart on all the cross references under the Patents Act. So, wherever you can do a control F on the act and find all the references, and you can make a chart with the provisions, type of reference, reference to which part or reference to what, the section or the relevant rule, and the gist of it, so that it becomes easier to memorize. So this pertains to the first requirement is that there has to be a reference to the application number. Then or there is an acknowledgement by the person who made the assignment that the assignment relates to the invention in respect of which the application is made. The person who makes the assignment should say that this assignment is pertaining to this. Application is not mentioned, the number is not mentioned, but he says this is with regard to an application. It is clearly identified by the person who makes the acknowledgement. It is clearly identified that they are talking about a particular invention. So the person who makes the assignment acknowledges the invention. So there is no doubt. So what is the objective here? In the first case, a person who reads the agreement should know what the invention is. In the second case, we say that the person who makes the assignment should acknowledge that this is the invention that is being transferred, or that is being that is for which they are seeking a direction, or there is a decision of a court. Say there was a dispute with regard to inventors, or dispute with regard to an agreement, a joint development agreement. Two institutes come up with an agreement, a memorandum of understanding, and later on they have an agreement to develop an invention. Two institutes. So researchers from both the institutes do work and file an application. A third institute now comes and says, I was also involved in the project, I should also be shown as an applicant. The first two institutes say that no, you were not involved, and that becomes a dispute. So the third institute approaches the court of law with lot of documents to show that it was also involved, and assume that the third researcher or institution is successful in getting an order from the court of law saying that yes, you made a contribution to the invention. With lab notes and evidence, they are finally able to prove that. Now based on that court order, you can make a direction. So the court order will very clearly say what are the facts and circumstances of the case, what invention they are pertaining to. It may also say that the other two people have filed an application, this is the application number, it is pending before this patent office, all the details will be there. So the controller has to insist on that court order, and I gave you the situation where there is a dispute with regard to who the applicants are, and one party gets a favorable decision from the court. Then here the controller will have to insist, or will have to see that the rights of the claimant in respect of the invention has been finally established by a decision of the court. So when you file form 6, you will file form 6 with the court order. That could be a question. Form 6, the accompanying documents in form 6 can be agreement, assignment, decision of a court, all of the above, or something like that. D, the controller gives direction for enabling the application to proceed under subsection 5 of, we are coming to it. 24, where one of the two or more joint applicants for a patent dies at any time before the patent is granted, the controller may, upon the request in that behalf made by the survivor or survivors and with the consent of the legal representative of the deceased, direct that the application shall proceed in the name of the survivor or survivors alone. What happens if there are multiple applicants and one of the person dies? In this provision, if there are 3 applicants A, B and C, and C dies before the grant of a patent, A and B, who are called survivors here, the surviving applicants, with the consent of a legal representative of C. C is dead. So C is legal representative, they get a consent, they can ask for a direction to proceed in the name of A and B alone. So, A, B and C were the 3 applicants. C died in between before the application was granted. A and B can make a request to the controller for a direction to say that proceed in our own names. Do not worry about C because C is now no more. Only condition is A and B will have to get the consent of the legal representatives. Whoever has survived, whoever are the successors in interest, whoever succeeds C, his family members in most cases. If it is a legal entity, then whoever legally represents that person. That is what we use the word legal representative of the deceased. You find the same language used in section 6. Legal representative can be an applicant under this provision. So, assume a case where C's legal representatives do not give the consent. So, they come in as applicant because section 6 allows them to do that. So, they will file a form 6 and they will say that we want to come in as the legal representative of the deceased applicant, and their names will be substituted. So, there could be questions on the course of action in the case of a death of a applicant. What could be the course of action in the case of a death of an applicant? In the case of a death of an applicant, the surviving applicants can proceed with the application in their names provided they get the consent. Okay. Provided they get the consent, they can proceed in their names. 25. If any dispute arises between joint applicants for a patent, whether or in what manner the application should proceed with, the controller may, upon application made to him in a prescribed manner by any of the parties, and after giving all the parties concerned an opportunity to be heard, that is a hearing, again you find a hearing coming here, give such directions as he thinks fit for enabling the application to proceed in the name of one or more of the parties alone, or for regulating the manner in which it should be proceeded with, or for both the purposes as the case may require. 25 deals with disputes between joint applicants. So, all the instances above where the joint applicants were not in dispute. A and B wanted to proceed after the death of C, C's representatives did not object, they gave consent, no problem. There is an agreement, all the parties have given consent, no problem. There is an assignment, all the parties have given are parties to the assignment, there is no issue. But when one person refuses to give a consent for bringing another applicant, so which means there is a dispute between the joint applicants, then what should be the recourse to the controller? Now, here it is said, if disputes arise between the joint applicants, whether or in what manner the application should proceed. Now, the controller can take a call on whether the application should proceed, okay, or in what manner it should proceed. The controller may, upon application made to him in the prescribed manner by any of the parties, and after giving them a hearing opportunity. So, when there is a dispute, any applicant can proceed to the controller under form 6. Any applicant. So the form 6 is not only for substituting names of applicants, form 6 can also be used to resolve a dispute between applicants. Okay, that is an important thing. If you see form 6 refers to all the sections on top. 25 is mentioned there. So, you will use form 6 and intimate the controller to say that there is a dispute between the joint applicants. So, the controller will hear the parties, give them a hearing. Controller can give such direction as he thinks fit. Now, this is the important part. Now, the controller can hear the parties and he can give such directions as he thinks fit for enabling the application to proceed in the name of one or more of the parties alone, or for regulating the manner in which it should be proceeded, or for both. So, he can either say that it shall proceed in the name of certain parties, or for regulating the manner in which it should be proceeded with. Either the controller can say this application shall proceed in the, if there are 3 applicants and one person is not cooperating, the controller can say it shall proceed in the name of A and B alone, whatever, for whatever reasons. Or it can say that it shall proceed in the name of A, B and C, but they should not do anything to stall the process. They can say that it should proceed further, because sometimes one applicant can stall the process. He can say that I am not interested, or he can go to the court and say that I filed a case, till that is decided, do not prosecute. So many things can happen. So, he can give a direction as to in whose name it should go, or the manner in which it should proceed. So, both these things can be done by the controller. Now, let us look at the corresponding rules. Rule 34, manner in which a request may be made under section 24. Rule 35(1) says it shall be made in form 6, and 35(2) says that a request shall be accompanied by proof of death of the joint applicant and a certified copy of the probate of the will of the deceased, or letters of administration in respect of his estate, or any other document to prove that the person who gives consent is the legal representative of the deceased applicant. Now, there are quite a lot of details in this. When you file form 6 under section 24, there is already a death. One of the applicants has died. So, you have to produce the death certificate. That is what is called the proof of death. Proof of death is what we can get from the authorities, called the death certificate. So, proof of death has to be accompanied. That is one thing. The second thing is, there has to be a statement of how the deceased person